Hello, it's Wayland Chow. Welcome to Contract Terms, Part C on boilerplate clauses. Boilerplate clauses. They're standard form pre-drafted contract clauses that lawyers will copy and paste into contracts that they are drafting. Common examples of boilerplate clauses are force majeure, confidentiality, arbitration, jurisdiction, governing law, and entire agreement. A force majeure clause is a type of boilerplate clause that we find in almost every contract. What it does is that if a event that happens that is beyond either party's control, and that event makes it impossible for one or both the parties to do what is required under the contract, that failure to perform will not be considered a breach of contract. So here is an example of a force majeure clause. So you'll see in the paragraph starting with 1.1.1 and so on is a list of all of the force majeure events that could excuse one or both the parties from performing the contract. So usually it will cover what are called acts of God. Which in this contract says or gives examples of acts of God as being fires, explosions, earthquakes, drought, tidal waves, and floods. So it's usually natural events, or usually weather related or other natural related events. Other force majeure events could also include war, hostilities, invasion, act of foreign enemies. We could also have rebellions, revolution, insurrections, contamination by radioactivity. You get the idea of what we're talking about here. So if any of those things happen, so the parties are no longer obligated to perform the contract because these events make it impossible to perform the contract.
Many contracts include a confidentiality clause, and such a clause would prohibit the disclosure of confidential information to a third party. Here's an example of a clause which says that the parties to the contract can use the confidential information only for the purpose of the contract, which is to evaluate a business, employment, or investment relationship.
Arbitration clauses are very common in standard form agreements between businesses and consumers. These clauses require contractual disputes between the business and the consumer to be resolved by private arbitration instead of through the public court litigation system. So in the Rogers Terms of Service, there is an arbitration clause, or two different clauses here, sections 40 and 41. The effect of these clauses is essentially to prevent Rogers customers from suing Rogers in court. They are forced to file any claim that they might have through arbitration, and that arbitration process will be set up by Rogers. And who knows? They might have set it up to their advantage and perhaps to the disadvantage of their customers. So as I said, it's meant to prevent access to the court system for their customers, and that includes access to small claims court. Small claims court in each province is usually designed to make it easier and cheaper for individuals with smaller dollar claims to sue in court. In Nova Scotia, the small claims limit is $25,000. So any claim that's $25,000 or less can be brought to the small claims court. Now, the ironic thing is that these clauses in the Rogers contract, which on its face prevents consumers from suing in court, These clauses are really of no effect in most provinces, including Nova Scotia and also Ontario and a number of other provinces that have consumer protection legislation that preserves consumers' right to sue in court, even where the contract requires arbitration. It makes these arbitration clauses in those provinces of no effect. They're not valid in those provinces.
A jurisdiction clause or a governing law clause specifies the law of which jurisdiction applies to the contract, or specifically, the laws of which province, or the laws of which country. This clause also specifies the courts of which jurisdiction will deal with contract disputes. The governing law clause in the Rogers contract is in section 45. What it essentially says is that the governing law and the relevant courts are those of the province in which your billing address is located. So if you're a Rogers customer and you live in Ontario, then Ontario law will apply. And also, if you need to sue Rogers, or if they need to sue you, they will sue that lawsuit would happen in an Ontario court. As well, let's say if you lived in BC, BC law would apply, and any lawsuits between you and Rogers would happen in a BC court, not in an Ontario court. A common boilerplate clause that almost every contract has is an entire agreement clause. Such a clause ensures that all of the terms of the contract are within the so-called four corners of the written contract, and does not include any verbal promises that have not been put into writing in the contract itself. The Rogers contract also has an entire agreement clause, and that's in section 43.